Hello and welcome to Brown Tales. Today, we will talk about the amendments to the Forest Conservation Act of 1980, which were recently passed in the Parliament. The amendments have received criticism from conservationists across the country as they seem to dilute the very purpose the FCA was enacted for. Over the course of the month, we will invite experts to walk us through the nitty-gritties of these amendments. In the first part of the series, our guest and expert, Mr. Debadityo Sinha, will help us understand the Act and the amendments. Mr. Sinha is a senior resident fellow and lead of the Climate and Ecosystems team at Vidhi Center for Legal Policy, an independent think tank doing legal research to make better laws and improve governance for the public good. Welcome, Debadityo. How are you?
I'm good, Shuchita. How are you?
I'm fine too. Thank you for coming. Like a lot of debate on the bill has been going on, and now that it has finally turned into an act, and after the Rajya Sabha passed it on the 4th of August, on the 3rd of August, sorry, I would like for you to throw some light on the subject. So, my first question is what exactly is the Forest Conservation Act of 1980 and why is it important?
Yeah. So, Shuchita, I think I have to go back to a little bit of the history part of it, like what conditions, this circumstances, this act was enacted. So, basically, what happened was this whole Forest Act, Indian Forest Act is the principal act which dictates how the states control, manage forest. It was a colonial law. Before that, I think 18th century, there was a British law and the whole forest department, everything came into existence. But the focus was initially for extracting timber from the forest. Forest was seen as a revenue generation thing. There are the resource kind of things, and then the focus changed after independence. And that time there was no Ministry of Environment and Forest. It was only Ministry of Food and Agriculture, and forests were actually seen as a part of larger agriculture thing. So, if you see the second forest policy, which was published just after the independence, I think in 1952 or something. So it clearly says that you have to prioritize agriculture and grazing everything on the forest. Okay, although it said that there will be village forest and protected forest, but the policy overall it promoted agriculture activities in the forest, and still they were seen as a more like a revenue generation and good for economic all these things. But what happened was for next 3-4 decades, the states were diverting forests for agriculture and other purposes like anything indiscriminately, and soon we realized that we are running out of the forest and these are being destroyed and all. So you all know the numbers in the parliament, like some lack of whatever being diverted. So the problem was the forests were in constitution, there are different subject areas where the rule making power is with the states and center. So the forest was actually the state list. So only states would have the power to make laws, and then central had minimum interference. There was no role of state. So I think in 1970s when we started making laws, environmental laws, I think water and wildlife, those are all in state list. They were brought under concurrent list, and there is history behind the Water Act and Wildlife Protection, how Article 256 was invoked because it was a state list. But by that time, the government realized that this forest is a national asset, and the central government should protect the forest. So the understanding that time was to protect the forest because states were not able to do their work properly. So this act was brought into consideration, and for the first time it says conservation of forest. Okay, and it was followed by this third national forest policy in 1988, which is still existing. It said that forests are important for ecological balance. It was the first major shift from the government that we see a forest as a need of the nation, and we must protect them for a ecological benefit, economic ecosystem services to the people. And one line says that any economic activity should be subordinate to the principal aim of the forest policy. So this act was brought to have a regulatory oversight over the states. What it does, it doesn't take away any power. Okay, so it says states are free to divert the forest, but what they have to do is, this act is very small act, 1.5 page act. So it says section 2 is the operative part. It says the state or any other authority, before diverting forest or for any non-forest purpose or de-reserving any forest, you have to take approval of central government. So it became an additional kind of approval kind of thing, and then the final approval is given by the state. So central government just approves it. Okay, there's a check something like that. So this is all the purpose of Forest Conservation Act 1980, to have a regulatory oversight from the center. And there was a forest advisory committee. It's important to understand that there was a forest advisory committee which started looking after this projects case by case. So it's up to 40 hectares, then goes to the regional office of ministry. And if beyond 40 hectares, it goes to the central government where the forest advisory committee is there, which is a scientific committee which sees, case to case basis, and they prescribe studies, assessment, alternatives, whether the project is required or not. This kind of things are there. It was no way stopping any development, but it was a check, like, that you don't exceed what is more than what is required. So that is the purpose of Forest Conservation Act.
Right. So, okay. So now, now the new amendments have actually, in my basic understanding, removed these checks and said that, I think it is facilitating the diversion of forests, if I'm not wrong. So I would just like for you to walk us through these new amendments, what exactly they are, because it says that, in areas of, in bordering area, in the where India shares borders with another countries, so there it's going to be easier to divert land for military purposes and stuff. So can you please just in brief tell us the major amendments that the act brings now?
Yeah, so Shuchita, this is a little bit complicated, but I will try to simplify, like having the broad category of amendments. So first thing which this amendment does is to, what is forest land? So it tries to modify that, not modify it. The government says in the preamble they want to clarify it, because what happened was in the 1980 Act, we didn't define what is forest in the Conservation Act. And it created a lot of problems because state would only see the forest notified by them under Indian Forest Act, the colonial law, under which we have reserve forest and protected forest notified. So those as a forest, and they started and they continue their same thing. Okay, so some petitioner like Godavarman, they approached the Supreme Court when the forests were being felled in the Nilgiris. And states say that we are not violating the law because this is not forest. So Supreme Court said, they just interpreted what is forest land. They said because it's not defined, so we say anything by the dictionary meaning. But it doesn't mean every forest will be falling under the Conservation Act. It clearly clarified. First is the forest has to be notified under the Indian Forest Act. That is first thing. No doubt in that. Second thing, Supreme Court said, in any government record, if the term land use is mentioned in forest, then it will be considered as a forest for the purpose of the Section 2. That means you have to take permission from central government. Third thing they said, there are a lot of areas which are forest-like areas, okay, which looks like forest, and communities and scientifically they are all recognize them as forest, okay, but they are not in the record or notification due to some reason. And the court said that the court cannot do this because court doesn't have the power, and we cannot have this kind of, India has so many different kind of forests. So states have the ultimate power and they have the responsibility. So why don't the states identify those kind of forests and declare them as deemed forest? The deemed forest term was used for that specific purpose. And lastly, the court also kept the matter open for anyone to approach the court if they're affected by this. So it is also one of the longest pending matter. Now what happened was, because it's in court has interpreted, and there are so many different interpretations by different people, different things. So people started misusing also. Some people have used it for better thing also, but people have been misused also. Okay, like some officers, they start to harass someone. Okay, local administration. And if you're cutting your garden, then maybe you are cutting the forest. But court has also clarified that, if some land was not previously forest land, but you plant trees there, it is not considered forest. Okay, it's very clear. But this later orders, they didn't. No one followed those orders. Later, what Supreme Court has clarified. So for example, if your land record doesn't say it has forest before, and nowhere it was written forest before, so until unless state declare them as forest, it is not forest, even if you plant trees. But people started misinterpreting it, and jo bhi hai, this thing happened. So what this amendment does, one good thing is that they have clarified this aspect of recorded forest. What is recorded forest? They have said that any land which is part of government record, and they mention specifically what is government record, it includes the forest recognized by the village council and recognized by the state. So it is a good thing. But the bad thing about the amendment is that there is exempt certain kind of forest. Okay, now coming to that, this is very technical, but you have to understand it. So I will try to simplify it. So what happened is, I told you that there are lands with forest-like areas which are not recorded, not notified, and these are supposed to be declared as forest. either under Supreme Court's order or by the state. So, for example, one example I can give you is that when the zamindari system was abolished, so the state, lot of land was given to the forest department, and these lands were supposed to be declared as forest. So, when a state declares forest under Indian Forest Act, we have to first notify under Section 4, settlement happens, then Section 20, and then you declare section reserve forest. The process didn't begin for many of those areas. This is the most disputed kind of area where ownership is sometimes the private person. Forest department tries to have control. Some places the forest department has control. People say it is our land. So this kind of disputes happen. But on paper, there is some communication. This land has to be with the forest, notified the forest. One thing is this. Second is there are lands which are traditionally conserved as forest, like in Delhi, we have Mangar, in Rajasthan, we have Oran, and these are not very like wood kind of thing, trees. So it's a misconception that, forest means you should have a dense for trees. It's not like that. Even we have desert forest ecosystem, which has like shrubs, all this kind of thing. So these are the traditionally conserved areas, and these are supposed to be declared as being forest. In the Supreme Court, like matters has been going on. So this amendment is completely silent on those aspects. Okay. So one can say it's entirely on the state whether they declared them or not, but it takes away certain powers from Supreme Court because the courts will only interpret when the law is not clear. Okay. The third exemption which it gives is in the terms of land classification is that it exempts the diversion of forests by the states before 1996, the order of the Supreme Court. So it says that if the state has diverted forest land before 96, it will be exempted from the Forest Conservation Act. Now my concern is the act came in 1980. The Supreme Court just interpreted what is forest land. If the states have diverted any land for non-forest purpose, this still dead is forest. I'm not talking about the failure to comply where there are cities being built up or people living there. I'm talking about those forests which are still, they exist as a forest. Okay, they are owned by maybe big corporates. They have bought those lands, but they can't do anything. Like a greater portion of Aravalli is like that. Okay, developers have bought those land. They are forest, Mangar forest, like that thing. So those kind of lands can be, you can say the state had diverted before, after 1980, before 96, but because the amendment legalizes them, you cannot do anything. And when Parliament passes a law, then courts usually don't interfere until unless there is a very great constitutional violation in there. This is one concern. Now, this is one part where the act applies or not applies. The second part is that how we see non-forest activity, because the act says Section 2 under Section 2 that you have to take permission from central government for any non-forest activity. Now, if you change the non-forest activity to forest activity, just for us in the law, you say zoo or ecotourism or recognized survey for mineral, all this thing. If I say these are not part of non-forest activity, okay. If I say wireless communication towers will be not considered as non-forest, will consider forest activity. Our concern is that these activities should be helping conservation. It should not be against, because the purpose of the act is to conserve the forest. But you tell me zoos or ecotourism or any safari, how you can, especially zoos, you cannot tell them in situ conservation. These are like, they should not come at the cost of natural forest and biodiversity. This is a fundamental question this act exempts. Now, other exemptions are for public utility, roads and amenities, for security infrastructure, and also roads, strategically important, national important and national security linear projects within 100 kilometers of the border. This is one where they're saying. Now, my question is that, one, for the roads, the government has not given any justification like why they need this. Only justification JPC they have mentioned is that only 4% of the projects are defense rated. Fine. Maybe the need was 4%, but the question is whether they were being stopped anytime before. No. Even the government has given them very fast rate of clearances within like even a very short time, within few weeks or 1 month like that. Okay. Not a single project has been stopped. The good thing about the FC Act is that it is a check, as I mentioned you. It didn't has stopped any project, but it has ensured first the project permit apply only for the land required. Okay, they will not take it as a luxury. They will take it as need based. So when I apply, I will make sure that I only take the minimum land required. I will make sure I explore all the alternatives. Okay, suppose my road is going through a eco-fragile region which is prone to landslide or is a habitat of a unique biodiversity. So I know when I go to FSC, I will waste my time. So what FSC will say, you find alternatives, it's the habitat of resistance. I need to realign the road, or why don't you keep these things? But now what will happen? These checks are not there. So I will not be bothered. So for suppose I am an agency, so I will just say I need the road, just build the road. There's no need to follow any other state of anything. Other thing is for this, this is for international border. That is fine. The other thing is about the internal, anywhere in India, you have exempted public utility up to, I think, 5 hectares or something, or security infrastructure for 10 hectares, something like that, and 0.1 hectare around the road. Now, my point is that if I know I am entitled for 10 hectares of land, why will I apply 1 hectare, 2 hectare? I will always try to get as much land I want. This is a basic human tendency, irrespective of any government agency or private agency. Okay. So this is one aspect. Secondly, is that was there any need to exempt these activities? Okay, what is the urgency to do that? Because FSC, this, as I told you, these are checks and balances. Roads and amenities, and these terms are so vague. Public utility can mean anything. It can mean a banking office, it can mean a hospital, it can mean a mall. You can say public utility is a public utility. Similar roads and amenities also. You see that all this this malls around toll plaza. These are all public utility, but these are like mini township in themselves. They have parking spaces for big trucks and separate. They have restaurants also. Now they're building hotels as well. So in the name of public utility and all this thing, you can do anything you want. The other thing is that last thing I want to say, where it is problematic, exemptions, because central government has kept many of this lawmaking power within themselves. So they are said as specified by the central government through rule or through orders. See, the term is rules and orders are different. If you say rules, all the rules under any act, they has to go to parliament. So basically you have to put in the public domain, invite comments, then go to parliament, then the rule is passed. But when you say prescribed by the order, it means the office order. So, today minister or someone says, I am having some problem. Why don't you change this thing, public definition of public utility to this thing? Why don't you include, like hotels in the purview of public utility? Next morning they will notify this order. So where is the scrutiny? So this kind of things are actually problematic. So we don't know how will play out. But in last few years, we have seen most of the laws are not being made to strengthen the safeguards. They're all to dilute. So these are things summary. I hope I'm able to explain what the amendments are.
Right. So we have covered the amendments as well as the implications, which was my next question anyway. So now, just, as a discussion, I wanted to ask you, like, on one hand, the government promises that, at least 25% of country's area should be brought under forest land. And on the other hand, such rules are passed, such acts are passed. So, like, what do you think about it? Is it not like diabolical?
Yeah, definitely. See, if you see the preamble, if a normal layman, he reads the preamble, he will be very happy, And the minister in the parliament also said, this act is supposed to increase the green cover, okay, and it will increase the forest cover. Now, it's very funny. In Joint Parliament Committee, they have mentioned that even if we change the land to some other purpose, but we will continue identify those areas as forest. Okay, so even if we develop a zoo, even if we develop some infrastructure on this, but we will see it as a forest. This is one thing. So first of all, you are destroying natural forests, which are far more benefit of carbon sequestration and other purpose. And if you see the entire focus on this amendment is on carbon sequestration. This is a term which has been glorified for everything. But tell me one thing: does forest mean only carbon sequestration? Is one of the basic function as act as carbon sink called sequestered carbon. But forests are beyond that. Forests are ecosystems as well. It provides habitat to wildlife. It acts a catchment of rivers. It is a hub of biodiversity, very unique. And it's most importantly, until like India, which is so populous and all this, people are dependent on forests for many things, for fuel wood, for forest produce, for their livelihood, everything. So you cannot, negate all these benefits and say only thing we are bothered is about carbon sequestration and economic whatever benefit you want to take. Now the other thing is that when you say you can compensate those forests by planting more and more trees, now you go to any place to see this compulsory afforestation, so they are like big failure. Why? Because first of all, we don't go as an ecosystem approach. We don't see the ecological history of the site. We don't plant native trees. We don't try to recreate the same ecosystem. For example, in NP or any places you see, they are like not a very dense forest. Most of them are like open forest, and they have a unique assemblage of biodiversity, like herbivores or carnivores. If you change those things, species will not survive. Take example, cheetah. You brought a cheetah from other land. You said we have created this thing, but they're not surviving because it's not an ideal ecosystem. It will take many. Evolution is a million of years of process. You cannot recreate those evolution by just planting trees for 10-20 years and you say, we can say, okay, you can have trees, but those are not more than a green desert. Because what happens is forest is not just standing trees, it's also a thing called stories of forest. So they are undergrowth, grasses and everything. There will be middle story, there will be top canopy, there will be open field, there will be wetlands. So, it is a whole ecosystem functions like this. This complexity is more important in the forest. But all the plantation you see, they are monoculture of one or two selected species. We have seen kikar being planted in places like Kutch or other places. I was reading a report, like how the first department and the agencies plant. So their whole focus is on fast-growing trees and create trees, number of trees. But the other purposes is completely out of the discussion. So that is my major concern. If you go this way, you can create 10 more problems. Anything you do at an industrial scale without respecting the ecosystem and the local needs, it is bound to be disastrous. I'm telling you, you can take me on record. In 20 years, you will see what disaster this plantation business will bring to India.
So that was Mr. Debadityo Sinha throwing light on the important amendments that have been brought in the Forest Conservation Act that actually undermine the act. Thank you for having us with you, and thank you for listening to the podcast. Stay tuned for the next part of the series where we will have Mr. Tushar Das, a forest rights expert, who will tell us how the Forest Rights Act will be impacted by these amendments.